Welcome, everyone. Thank you all for joining us here today for this important discussion. We'd also like to extend our gratitude to all of our panelists who are here today as well. My name is Shannon, and I have the pleasure of introducing our esteemed panel. And we also have the honor of having Professors Nicholas Bala and Dr. Rachel Birnbaum, who will be sharing the results of their recent study that they conducted to help understand the experience of family lawyers as a result of the pandemic and the adoption of virtual technology in family court. First, we have Professor Nicholas Bala, who has been a law professor at Queen's University since 1980 and is a leading expert on family and children's law. His work is frequently cited by all levels of court, including the Supreme Court, and much of his research is interdisciplinary, including a present project on the effect of the pandemic and the evolution of Ontario's family justice system and access to justice, being undertaken with Professor Claire Houston and Dr. Rachel Birnbaum, who is also with us here today. So Dr. Rachel Birnbaum is a distinguished university professor at King's University College at Western University in London, Ontario. She has extensive clinical practice and research experience in working with children and families of separation and divorce. And she has presented nationally and internationally on parenting assessments, child legal representation, children's participation in family disputes, and on the intersection between law and social work. We'll also be hearing from some of the family law ad hoc steering committee members. So first off, we have Brian Galbraith, who is the owner of Galbraith Family Law, which has 6 offices in Ontario and 16 collaborative lawyers. Brian is the president of the International Academy of Collaborative Professionals and has served on its board for several years. He also has helped train hundreds of collaborative professionals and conducted workshops on the international stage. Next, we have Ram Shankar, and Ram Shankar has experience as a lawyer for the past 28 years, starting from the time when he was called to the bar in 1994. And Mr. Shankar has 2 master's degrees under his belt, a master's of law from Dalhousie University and a master's of development economics, again from Dalhousie. Next, we have Gene C. Coleman, who has been practicing family law since 1979. He has authored many legal articles and has served on a number of committees that have addressed access to justice issues. He passionately believes in procedural fairness, and that commitment to fairness brings him here today for this presentation. And last but not least, we have Russell, who is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. And with 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce. And Russell has also authored 4 books on separation and divorce and is a fully trained collaborative practice lawyer. He also shares his knowledge and experience by speaking at conferences on collaborative practice, marketing, technology, and the law. And just a quick note before I pass things over to Russell is that the panelists will also be answering audience questions as time allows. So if you would like to submit your questions, you can submit them through the Q&A. And once the presentation starts, I will be available off screen for any general questions or any technical support you may need. I'll pass things over to you now, Russ.
Thank you, Shannon, for those kind words. To stay on for a minute, tell us a little bit about yourself. So this is the first poll we run. I want to get an understanding who our audience is. So we're going to give everybody a minute or two to put your answers. But Shannon, I understand after today's presentation, there'll be some show notes. Can you tell us a little bit about that?
Yeah, so I'll be following up tomorrow just with resources that are mentioned today throughout the presentation, as well as the survey that Professor Bala and Birnbaum will be speaking to. So that will come tomorrow to everyone who's registered for the event, so you can expect that.
Yeah, and I want to thank everybody in our audience for attending. Usually we have 4 or 5 polls, but I think we're only going to do maybe 2 today. Is that right, Shannon? We want to present.
Yes, we have 2 polls.
We want to present the findings from the survey, and then at the end of our presentation, or the professor's presentation, we're going to give our audience a chance to give us their thoughts, and then we're going to go through our panel, and we're going to have some input as well. Or I think at the end of Jean's presentation, we're going to run the poll. So thank you, Shannon. Let's make a start. So Professor Bala, let's see what our poll results are first. Okay, 68% family lawyer, legal professional, 12% practicing in another area of law, 18% another field, and other, you can put in the Q&A. So thank you everybody for answering that poll question. Now we're going to flip it over to Professor Bala, and we're going to take a look at the survey results.
I'll be presenting with Rachel Birnbaum, who worked on the survey with me. Claire Houston from Western was also involved in this project, but unfortunately can't be with us today. So we're very grateful to the survey, to those who supported participation in this. We had a very good response rate. A number of organizations were involved, and we're certainly grateful to the lawyers who responded. And I'm sure many of you on this call today were among them. So the survey that we undertook is intended, it's really part of an ongoing project to look at the effects of the pandemic on family justice and how that will be evolving over time, how that has evolved and how it will be evolving. And in particular here, surveying how family lawyers have seen the effect of the pandemic and now moving out of the pandemic. And particularly, as you'll see at the end, focusing on some policy questions, where should we be going? So we had about 130 respondents altogether. And as is typical in surveys, most of the respondents were women. A good question whether most family lawyers are women. We're not sure about that. Next slide, please. And the vast majority of respondents were white, are white. And this, again, I think pretty well reflects the family bar. As many of you may know, or all of you must realize, the percentage of visible minorities in Ontario is roughly 30% of the population. The bar is changing more slowly, and I say that myself. We're seeing change in law schools. Certainly our student population today, our graduates, are more racially diverse, and there are challenges arising out of that, but I think the profession and the bench and the law schools are adjusting to that. And the respondents were a fairly experienced group, and indeed we see and we have the what one might call the graying of the bar, that most of the respondents have been in family practice at least 20 years. And most of the respondents, and I think that again this reflects largely the practice of family law. Almost half are sole practitioners, or in small firms. A number are in larger firms, and this survey, we were very pleased. Legal aid clinics picked this up, and we had about 30 respondents from legal aid clinics. And as I'll discuss in a moment, they understandably have a different perspective on the effect of the pandemic and virtual family court. Next slide, please. And the survey, the respondents were around Ontario. As you can see, the largest number in the GTA, but we felt we had pretty good representation from across the province. So the first substantive question that we asked is about how people are finding online filing. And I should say, what we see is that a majority consider that things are going pretty well or very well with online filing, but a significant minority disagree. And I believe this is an area where we're seeing a lot of challenges as we've moved from a paper-based filing system to one that is electronic. Some places, the court staff have done well in doing this and are very responsive and supportive. In other places, the court staff, which were in fairness hired in a paper-based environment, have not have had, from the perspective of the staff, probably have had challenges in doing that. From the perspective of lawyers, have often been rejecting documents without saying what the problem is, or not giving enough specificity about what the problems are. I think that this is the experience across Ontario is suggesting that this is something that local bench and bar committees really need to work on. If it's a problem in your area, the work sitting down with the judiciary and ultimately meeting with having the court staff involved through an appropriate process is very important. it's a challenging area because the court staff, one must realize, one thinks, oh, the judges tell the court staff what to do. No, the court staff are independent, unionized, they have their own administrative structure, but they're ultimately responsive and want to be supportive, but there's a lot of challenges there in some areas. Corresponding with the issues around online filing is case lines, which of course is a different but related system. Here, a little more concern about case lines than about online filing. Again, some variation across, certainly across, to some extent, across regions. And here, I think that this is obviously an issue at a higher governmental and court-based level. And we may be seeing some evolution, but the basic idea that it's going to be an online court based system is going to remain. The question is, how can it be improved? And there's certainly work for the bench, bar, and government to be working on in this regard. I know there are some specific issues with case lines, but it's not going away. I mean, the system is not going away. It might evolve, but it's an important part of shifting to an electronic environment. And I should say some other court systems, one looks at the federal court, for example, they probably have better document management than we have in the family courts in Ontario. So it's certainly a work in progress. So here we were asking about how lawyers feel about having clients attend meetings with them virtually rather than coming into their offices. And most lawyers strongly or somewhat agree with this. And I should say the disagreement is primarily in people in legal aid offices. So here we see this divergence, and understandably, most private clients and even some on legal aid certificates can attend a meeting with their lawyer virtually, and the client can scan documents and screen share and so on. The reality in legal aid clinics, and not just clinics, but mainly duty counsel, is it's very hard for duty counsel to have meaningful interaction with many clients if they're not actually in the office. This was a huge problem in the pandemic when people could not come into offices. Obviously, we're seeing change now, but I think the vast majority of lawyers in private practice prefer having clients come, meeting them virtually, and recognizing that, of course, that's going to vary by the client. And how do clients feel about this? Again, the vast majority or substantial majority of lawyers in private practice think that clients, for both practical reasons like the cost and time of coming to an office, but also the comfort. I'm sure many lawyers have had the experience of interviewing someone in their office and the client saying, "Oh, I need that. Yes, I have the document, but I don't have it here." The client's at their home, they're likely to see that. Of course, there are challenges with some clients who may not have separated and want to meet with the lawyer in person, or and so on. And again, legal aid, duty counsel clearly recognize that many of the clients are going to prefer coming to the courts, to their office, which is often in the courthouse. So, and here we come to the question about preference for court hearings, virtual court hearings. And again, a substantial majority of lawyers prefer having a virtual court proceeding rather than going to family court. Significant savings, as we'll see, in terms of time, money for the clients, and overall efficiency. Here, the variation is partly the duty counsel issues. Partly there are some lawyers who, for a variety of reasons, prefer attending in court, but they're a clear minority. And again, most clients, and here even more than the lawyers, prefer virtual court attendance. This is, of course, the lawyer's perception of what their clients want, and other research has and will be done on it. But for most clients, again, they're the practical issues of traveling to court, particularly if they don't live close to the court or don't own a car, and which is a situation for many clients. Also, the questions of comfort and or safety. We'll come back to the issue of family violence. So a significant preference of clients for virtual court attendance. And here we're getting into questions of, this is the first of a series of questions about the cost of access to justice and the effect of allowing or having virtual family court. And so this was just to get a baseline. And as you can see, most family lawyers, and I think this is true for those who didn't answer the survey, are in the range of $300 to $500 an hour. People who talk about, oh, family lawyers cost $7,000, $8,000 an hour. That is true of a small percentage of lawyers, I think primarily in the downtown Toronto area. And you see, I don't charge by the hour. That was people in the clinics. Thanks. Next slide. So we tried to, one of the things in this study, you'll see this in the slides, in the next few slides, we tried to segment out what was happening at different stages of the pandemic, which we did by year. The first, and personally, I think others looking back, can we remember that first most challenging year, and then the period of slow opening up and more significant opening up in this past year. What we'll see in these next three slides is there were some increase in fees during this period of time. And here in the first year, yes, a relatively small percentage increased their fees during the pandemic. And here again, the second year, what we call the limited access period, as people were starting to get the vaccine, again, slightly more increased, but most no change. And the third one, more increased in this past year. And overall, I think it's fair to say, over the last 3 years, there have been some increase in fees per hour, which of course reflects an enormous amount of inflation. There are very, very few things other than university tuition that have not increased in price dramatically over the last 3 years. We didn't get into the details of it, but I'm not sure that in real terms we've seen an increase in family lawyers' fees over the past 3 years. And here, in fact, I think I'm turning it over to Rachel.
Thank you, Nick. So as Nick said, we had a fairly robust sample. In total, there was about 141 participants. But as many of you know, not everybody answers every question. So these next set of questions about net income, there was a drop, not significant drop of people answering, but there was some drop. So this is asking the question again, sort of from the beginning of the pandemic, sort of did your net income change during the pandemic? And you've got, quite a spread, even spread of increasing your net income, decreasing, as well as no change. But if you look at it in terms of percentages, there was about a 29% increase and a 34% decrease, with 37% saying there was no change. With respect to income change during the opening up, the limited sort of access period, you'll again see sort of a variation of almost a increase of 33%, a decrease of about 25%, and a no change of about 42% in terms of during this period of time. And then finally, looking at it from the kind of opening up period, you'll see there was an increase of almost 36%, a decrease of about 19%, and again, a significant no change in net income during the opening of about 44%. So then we turn to how much does your average client save in terms of per court appearance when attendance is virtual. And again, there's Fortunately, there's no increased cost, but a significant number said that there was no difference, almost about 28%, and a greater than $2,000 was about 7% in total. In terms of your average client, in terms of saving, in terms of court appearances, again, there was a significant no difference. And about from about the next one was about from 2,500 on, about 20%, versus up of 5,000 or more, about 13%, sorry, 13%. I was looking at the numbers, which is kind of interesting in terms of the amount of client savings of the fees for court attendances. When you shift to the remote delivery of family services in terms of providing, allowing you to provide more services, clearly it really helped lawyers across the province reach out to many jurisdictions. And when I combine the significantly more and the somewhat more, you're looking at close to about 50%. Which is quite significant. So how has remote delivery impacted? You've got, again, quite a large number when you compare, when you collapse significantly and somewhat more into about, again, 54% impacting with respect to the settlement. No, sorry, with respect to the number of clients being served. Now, with respect to settlement, it's again quite sort of evenly separated out when you've got significantly strongly support. You've got close to 30-40%, which these are quite significant. Now the next set of questions are favoring a presumption of in-person for any contested proceedings. And it's quite a huge amount. Again, when you look at strongly support and support of returning. And I know the question might have been awkwardly worded, but I'm hoping, but we do believe that it's, we were looking at in person in terms of these contested proceedings. The same thing for a presumption of in person if one or both parties are self-represented, which is pretty significant. Even again, kind of evenly balanced out to sort of half saying yes, half saying no, some having a neutral position. And this goes back to what Nick spoke up earlier about having some of the people who completed the survey from legal aid. There's certainly a different interpretation, and rightly so, in my opinion, in terms of in-person versus virtual. But while we had a good robust sample, there were no, looking at correlations, again, not causation, but correlations, sort of associations. There was no, we looked at the 3 different time periods. There was no difference. We looked at gender. We even looked at time called to the bar and by gender. There was pretty well no significant. And in this respect, no significant is actually quite significant that, that there's no difference between these. Although it asks a whole bunch of other questions that we might want to look at later as well. So then we asked some open-ended questions with respect to everybody on the impact of virtual court on family violence and clients with disabilities. And this is where we got the vast majority of lawyers, both in private practice as well as in from legal aid, and a lot from legal aid, saying that virtual hearings are by far much less traumatic for those that are experiencing family violence issues, that it's much more comfortable for the clients to be in their homes. They don't have to deal with the person that they feel threatened, or the issues around safety, that it's online. But again, that the administration of justice, the courts and the judges, need to be sort of aware of this when there are issues around family violence, and why it might be preferable to be virtual, but also across jurisdictions, the differences between the North and the South with respect to this particular issue as well, of not, some of them not having to travel as far, and it being much more comfortable and easier, and especially when it's issues around family violence, or even mobility issues. People who have mobility issues or cognitive issues, sometimes it might be better, certainly online. But the vast majority talked a lot about, with respect to family violence, it should perhaps be parceled out, with it being much preferable for it to being virtual hearings. Then we asked the last couple of questions on the impact of virtual court on your work as a lawyer and kind of going forward. And again, there was a real mixed, many lawyers would much prefer having virtual court, that it made sense to them, that it was saving, there were cost savings, but we still don't have, that I believe, any sort of real robust literature or research on what the actual costs are, because they're very difficult sometimes to calculate them, because a lot of it depends on context. Whether you're in which we asked earlier, whether you're in are you a sole practitioner? Are you in a small firm, a mid-sized firm? That would make a lot of difference with respect to cost savings, and your staff and how many clerks you have and who does what, etc. Not easy to carry out, much like it's not easy to carry out for the courts in terms of the cost savings for the courts. And particularly when they don't even have the most up-to-date technology as it stands. Many people still had issues around the on-filing system and the case lines. And, you have to take a step back. If lawyers are saying, I'm having problems with, getting documents into case line, or it being rejected, try and imagine what it's like for those self-represented litigants who, this is a whole, it's hard enough to be a self-rep in court as it is, but now you're being asked to, put in these documents, and they don't always work. And of course, also in doing a lot of the different number of studies that we have done as a group, finding out that judges sometimes don't even get the information through case lines. That, there's certain documents that don't get in, and then they don't see them, and you make the assumption that the judge has it when they don't. So there's some real issues going forward around who has what, and what's everybody looking at. And it's almost like you have to start every court appearance of, what documents does everybody have in front of them, and what are you looking at, which creates even more time. So like every study that's done, not just our study alone, more women typically participate, yet there were no gender differences. And this is only a snapshot of a limited number of lawyers who practice family law across the province of Ontario. And there needs to really be much more research exploring the needs of family violence victims and those with disabilities, cognitive or physical, in trying to access family justice in general, as well as more research about the impact of technology on different populations and geographic locations. We in the South here in Toronto we take all of this for granted until there's a storm that happens, and then even Toronto folks go, oh my God, the electricity is down. But imagine what it's like for people up in, Cochrane or, Thunder Bay, etc. There's some real serious issues, and we need to have much more research around that. So this is really just kind of touching the surface. Nick, I'm going to turn it back over to you.
All right. So by way of summary of our findings, it's clear that the majority of lawyers, particularly those in private practice and their clients, prefer to have virtual meetings with their lawyers done virtually. And again, there will be, exceptions, and lawyers will govern their practice accordingly. I think lawyers are also starting to use technology more for intake, for initial having clients prepare documents and so on. So technology is clearly affecting the practice of family law. A significant finding that we had was that the use of virtual meetings and virtual court has allowed lawyers to service a broader geographic area. And I think this is particularly significant for legal aid, for clients on legal aid certificates. Legal aid has not significantly increased its fees, and there is a smaller portion of lawyers across the province who are prepared to accept legal aid certificates, and they're certainly not spread around the province. And so it's not uncommon for a client, let's say in Sault Ste. Marie, to say, I can't find a lawyer here who will take a legal aid certificate, but there is a lawyer in Toronto who will take this virtually. And that's good for access to justice. I think that many judges in what we can call more remote areas are somewhat more flexible about allowing virtual appearances. And they know, if I don't allow this legal aid client's lawyer to appear virtually, there'll be no lawyer, and there'll be effectively no certificate work done in this area. And so we see, I think, more flexibility around that. And that's going to be an area that we need to increasingly work on with the government, Legal Aid Ontario, and the judiciary, as well as the bar. I think that we've seen in general, broadly, although there is some variation and we'd like to have more detail, that virtual court, virtual involvement with clients technology has reduced the cost of providing legal services for individual clients. And this is therefore, virtual court and use of technology is improving access to justice. As Rachel pointed out, this is particularly true for litigants who may have disabilities and problems in traveling to court or being in court, and especially those who may have family violence issues. We certainly see in the survey that there is a difference for different segments of the family bar. So those in private practice, those in more remote areas are having different experience from those who may be legal aid staff lawyers or are in major metropolitan areas. Where we see differences of view, at least in this survey, is what is the effect, and I think this is a concern for the judiciary as well. Is it true that having people in court, especially for a settlement conference, but for any conference where there's a discussion about settlement, having people in person in front of the judge is more likely to produce a settlement? Some judges think that. Here, the response to the survey had mixed views about the effect of being in person as promoting a settlement. And again, the issue of self-represented litigants may be different. As lawyers in private practice, one's experience would be, I think, that most of the files one has, there's a lawyer on the other side. Self-represented litigants are not exceptional, but they're not the most common for a lawyer in private practice. On the other hand, having, from a judge's perspective, there are a lot of litigants where both are self-represented or one is self-represented. Clearly, we're in a transitional stage as a society, and even more as a court system. There are differences in criminal court, which I think is pretty well all in person now, except of course if for the accused is in detention. And whereas civil proceedings, particularly high-end commercial cases, where some parts of it, international commercial arbitrations, are being done increasingly virtually. Family is sort of in this in-between stage. We have a set of policies that are in place. And next slide, please, Rachel. One of the things that we're seeing is, in some ways, arguably, Ontario is in a bit of not in a leadership position in this regard. I realize it may be hard for some of you to read this. The main thing here is the headline captures it all, that the Chief Justice of Manitoba, Marianne Rivelin, who was recently appointed to that position, has a lot of experience on the bench, and says, in Manitoba, we're using virtual hearings more and more because of issues of remoteness. We have to do that. She also talks about about the value in other court systems, the federal court system. And I think there's no doubt that Zoom hearings, Zoom appeals are here to stay. The question is, what's going to be the balance? Who's going to be deciding? How is it going to be decided? And as we're going to discuss in a moment, Gina is going to be leading us in discussion. Arguably, the situation in Ontario, particularly in family justice, there's a need for change, both in terms of the rules and understandings, also obviously in terms of access to appropriate resources for both the courts and litigants. So I think we're done with this presentation. So thank you very much. There are emails. We're happy to correspond with people, but we're not taking questions or comments now because we're turning it over, I think, to Jean Coleman. So thank you for your attention. We're happy to hear from any of you individually.
Thank you, Nick and Rachel. It's a really insightful survey, and I think it really is reflective of what the bar is feeling in this area. For our audience members, if you do have questions, put in the Q&A box. We're going to save some time at the end, try to go through the Q&A. We did notify the Chief Justices and the Attorney General's office of this town hall today, and hope to share a recording of this presentation with those two offices. But Jean's going to take it over, and then we're going to hear from our panel in terms of the survey results and Jean's comments, and we'll have another poll at the end of this. So over to you, Jean. Thank you.
Thank you, Russell, and thank you, Nick and Rachel. I'm going to give over my views. Our committee has not taken a poll as such, and you please accept them. You can just glance at the outline of the topics to be covered. I'll be speaking for about 10 minutes. I won't read these, there they are, and let's just go to the next slide. So to recap again what Professor Nick Bala was just stating, their research reveals a rather pronounced preference for virtual family justice. The majority of the lawyers and clients seem to prefer virtual court. Virtual court generally reduces cost of resolution of family cases for clients, they told us. Virtual court assists the client who is vulnerable as a result of disability and family violence concerns. There is a difference in the ease of accessing technology based on geographic location, and we heard that LAO staff have different concerns than private practice lawyers, and of course we have to take cognizance because legal aid is all important in the family law system. And there is broad support for virtual family court if both parties agree and are represented. According to the lawyers surveyed, we found that the lack of significant legal cost increase, I would say, is very puzzling. And I would ask the researchers to please double check their data on that point, because I do know in our firm, which is of course a totally family law firm, we significantly reduce the costs to the client by having virtual hearings. We have a consolidated provincial practice direction for family proceedings in the Superior Court of Justice effective just a few weeks ago. The practice direction applies to all family court proceedings in the Ontario Superior Court of Justice, unless they state otherwise in their publication. It replaces all previous directions, notices, and whatnot.
Jean, Professor Bala had a comment.
Yeah, so I just want to clarify that we found, and of course we don't have exact figures, which is what Rachel was commenting on, but on the whole, the vast majority of respondents in private practice indicated that their costs, both particularly over the course of a file, but also for individual appearances, the vast majority reported that there was a reduction in costs, not an increase. There was a tiny number, and it's a good question, why some people said it was more expensive, but the vast majority have said that it's a decrease. I think, by the way, my speculation would be the increase in costs might reflect people who are saying they're having so much trouble with things like case lines that there's actually increasing their costs. But there's no doubt that having virtual hearings is a cost saving for the vast majority of litigants. So that's what lawyers are finding. The other side, of course, or another side there is, it may be a bit of a skew how the Legal Aid Duty Council viewed it. And so, we're sorry to interrupt, but I did just want to clarify that we don't need to check our data. We need to look back. And in fairness, it wasn't sort of a, it wasn't quite stated as clear as it might have been, but it's very clear if you go back to those slides that there is a cost saving and that virtual court does promote access to justice.
I said the word increase, and when I said increase, I should have said the lack of a significant legal cost decrease, and I used the wrong word there, and that was on your chart of the responding lawyers. Elsewhere in your paper, you said, well, there was a significant cost decrease, which makes sense, but on your chart of the views of the lawyers polled, many of them did not find a significant legal cost decrease. And I'm just one firm, small firm with a few lawyers, but there was a significant legal cost decrease, which is consistent with other findings in your report. But thanks, Nick. Tracy Pylon asked, do the practice directions apply to the Ontario Court of Justice? No, they have their own. I'll be talking about that momentarily. I'm talking now about the Superior Court of Justice direction. Part 3 of the SCJ practice direction deals with 3 issues: overarching principles, terms used in the guidelines, and presumptive guidelines to determine a mode of proceeding in family matters. With respect to overarching principles, 1, there's a discretion of the court, so that, quote, the final determination of how an event will proceed, watch this, guys, will remain subject to the discretion of the court. Secondly, access to justice. Does everyone have the necessary technology? That is key. Thirdly, self-represented litigants. They have their issues. They have their issues with technology, duty counsel assistance, inability to adequately address issues in writing. And there, in those situations, the courts are given a discretion to proceed in person. Fourthly, in-person hearings are important. In-person advocacy equates to an essential feature of our justice system. I certainly agree. That's the way it's been done. Feels really good to get your gowns on and go to court and stand in front of your clients and press them. But the pomp and circumstance is great. It brings forth the gravity of the situation. But does that trump, no pun intended, does that trump the right to have cost-effective justice? Hybrid options, the court says we should consider hybrid. Yes, we should. And 6, impediments to a virtual hearing. In that part of the paper, of the memo, I say there's nothing really convincing there. They talk about, quote, statutory security or other impediments to having a remote hearing, end quote. All this is solvable, my friends. You just need a little bit of money and some modest commitment to the family law system. These principles, these overarching principles discussed in the practice direction, give considerable wiggle room to judges and lawyers. The next part, under part 3, is the presumptive. There are presumptive guidelines to determine the mode of proceeding in family matters. I found that the child protection standards are listed separately, but they're very similar, not exactly the same, but very similar to the regular SCJ. FRO is appropriately listed separately, but it's quite simple. It's all in person unless the court orders otherwise. But with refraining motions, which is a FRO matter, some of them are virtual unless the court orders otherwise. Now I have a chart, and you'll see in this chart, I give the type of appearance on the left-hand side. In the middle, I marked down what is in this SCJ consolidated practice direction. And on the right, I have a section regional notices. Now, obviously, on the right-hand column, I did not put down every regional notice. And the where I have put it down, for example, the conferences section there, I arbitrarily took Toronto, Oshawa, and Central West, just as examples to show you where some regional notices differ from the consolidated practice direction. Next slide, please. Just go down here. You see that I've highlighted virtual in yellow and person in green and writing in whatever that color is, turquoise, blue. So there are differences, there are similarities. And so the long and short of it is, you really have to not only look at the consolidated practice direction, but if you do, you may go astray. You've got to look at your regional notices. You've got to look at court specific notices. And by the way, this PowerPoint as well as my talking points are available on request to Shannon Martel. Just send her an email and she'll be happy to send it out to you. I provided those 2 documents to her. Someone asked about the Ontario Court of Justice earlier. I briefly answered, and here it is. They have a practice direction or notice to the profession effective 11th of October 2022. And that tells us case conferences and settlement conferences in the OCJ are in person. Trial management conferences are virtual, motions are virtual. But use the court notice finder. Use it. It's courtnoticefinder.ca. I'll go on a little bit of a limb here, and I don't get a bonus from the organizers of Court Notice Finder. I think it approaches professional negligence if you don't use the Court Notice Finder. There are so many quirks and quarks and whatever you call them with respect to different courts and different regions that looking at a provincial-wide direction, whether it's OCJ, whether it is the recent SCJ, is not enough. You must use the Court Notice Finder. And you want to be really certain, go back to the source document. It's an essential tool. There are other sundry resources, and I've listed them here. If this isn't the comprehensive list, this is just a sample that so you have to click on. If you're in Toronto, you must click on that resource there. If you're in Central East, Central West, you must click on the relevant resource. And then in Court Notice Finder, you must check if, I don't know, if Cochrane has a specific difference from Timmins, let's say, just by way of example. Now to my observations. First of all, with respect to the research, wow, I thank you guys. The Birnbaum et al. Research provides a good, although somewhat preliminary insight into the impressions of the family law bar in the province. Their study proves that the bar, by and large, favors virtual as the presumptive mode, particularly where counsel and the parties agree. Secondly, with respect to provincial standards, the consolidated provincial practice direction is a good start to settling standards. So let's give credit where credit is due. But it is crystal clear that the various regions and individual courts will not and do not feel the least bit bound by them. And creative counsel who are seeking a mode of court appearance that departs from the fiat of their region, can they use the provincial SCJ standards to argue for something else? I can hardly wait to see a reported decision on that. Thirdly, avoiding virtual. The wording of the provincial direction, as I said, gives ample wiggle room to judges who favor in-person to simply order it. So Justice Ricchetti, you're in the clear. 4, access to justice. The main goal of the ad hoc committee is to ensure widespread access to family law justice. That includes some of the following. 1, reduce legal costs. 2, make both courts and legal services, whether virtual or in person, more accessible to the public. And thirdly, my pet issue, ensure procedural fairness for all. So I'll conclude with an action call. To better ensure access to justice, I call upon the Attorney General. I call upon the Ontario government. Let's throw in the Chief Justices there. Let's throw in the regional senior justices. I call upon them all to get together and to take the following steps. 1, ensure availability of technology, both in and out of court. 2, ensure availability of duty counsel and other supportive services, whether we're dealing with virtual or in person. 3rd, presumption. Where lawyers and parties agree to virtual, that should be, in Coleman's view, pretty much a hard and fast presumption. And that should be in place right across the province. Thanks for listening to me.
Those are excellent analysis, Gene. Thank you so much. We're going to do a quick poll, and the question is, do you favor a strong presumption of virtual hearings if both parties agree there should be a virtual attendance, or we'll call that the Gene Coleman presumption? But we're going to give everybody a moment to answer that, a couple minutes. And Ram, I know you have a court hearing coming at 1. I hope it's not in person, but I want to give you maybe 30 seconds or so while we're waiting for these poll results to come in, to give us your reflections on the survey and also on the proposal put forward by Mr. Coleman.
Well, thank you so much, as always, Russell. I'm grateful to the presenters for their outstanding analysis. And to add to what Mr. Coleman's, as usual, expansive presentation talked about, I just want to add one other point, which is when we analyze not just the Chief Justice's province-wide directions, but when we actually analyze each sub-region's directions, we find that there is some differences in between various regions. So I think one of the most restrictive is our Central West region, because here a number of hearings are still presumed in person for motions, long motions, etc. So just as an example, I had to book a long motion in Southwest, and my assumption was it was going to be in person, and then the trial coordinator said, "Oh no, absolutely not. It's by Zoom because that's the presumed mode." So if it's possible there, it should be possible anywhere. That's all I'm saying. So there should be, while there is wiggle room, I think more can be done in terms of achieving consistency and uniformity. So
Okay.
I'll leave it at that. Okay.
Thanks, Gene. I think
Thank you.
Nick, hand up.
Just a quick comment that I think what we're finding is a lot of regional diversity, and that's a strength of the system in that there's a lot of variation in terms of access to technology and so on, and that we should, at this point, we shouldn't be having uniformity.
Right. Okay. Let's post our results. Rachel's got her hand up. So as we look at the results, let's go to Rachel next. Just quickly, almost 70% strongly agree. The remainder, almost, well, we had 96% overall agree with you, Gene. So I think you've hit the nail on the head. 2% unsure and 2% disagree. Sorry to keep you waiting, Rachel. Did you want to make a comment? And then I'm going to flip it over to Brian.
Yeah, no, just very quickly. I mean, as an academic, I just want to be sort of a final thought. A famous saying is, it all depends. I think asking a binary question, virtual versus this or in person versus that, in my opinion, or in our opinion, is a bit simplistic. It really all depends. Someone commented in the Q&A about immunocompromised, whether you're a lawyer or a litigant, there's so many things that are going on that we do not know, who's walking into the courtroom, who is seeing lawyers, etc., that you really have to weigh a lot of different factors. And to simply say we should automatically do virtual or automatically do in person is too simplistic.
Presumptions can be rebutted. In the case of the immunocompromised, of course, that should rebut the presumption. If even one person is immunocompromised, then you have to accommodate them.
Yeah, it's a presumption. I agree. This isn't a hard and fast rule, and there'll be exceptions. It depends, that's sort of the classic lawyer answer to everything. But if the presumption is remote, as recommended by Jean, I take a slightly different view, but I'm going to give Brian some time first. Then I think that's going to improve access to justice and reduce costs. But Brian, I want to give you an opportunity to get your thoughts in here. We have the survey results. We have Jean's proposal. What do you think?
Yeah, I want to first thank the professors for doing this research and analysis, and the results are not really surprising to us who are practicing family law, that it does save money for the clients, but there is a section of society that doesn't have access to technology, and as was suggested by the Chief Justice of Manitoba, we need to come up with solutions for those people who don't have access to technology, and such as computer hubs or some way of giving them access as much as possible. But I frankly, I feel like we're going in the right direction, that there is at one point we were fearful that everyone would be pulled back into court, but I feel like we're moving away from that, and people are starting to accept that there is some real advantages to administering justice remotely, and that family court is not a building, it's a process, and we're moving in the right direction. So I'm happy for that. So thanks again for this research, and we'll have to see how what evolves over the next months and years.
And in fairness to the courts and the administrators and the judges, they're having some issues with getting the technology up and running, and supply chain issues, and getting the courthouses proper internet connections and all the rest of it. So it's a juggernaut that's not going to change overnight. But I certainly agree that the presumption being remote, perhaps a few exceptions would be if somebody's liberty was uncertain in terms of contempt hearing, enforcement hearing, or enforcement of an order. Those would be the exceptions to the rule, in my view. The rest could be fully remote. But I want to be mindful of our time. We've got 12:59 and our host magically appears. Welcome back, Shannon. I want to thank everybody for all their hard work in continuing to look at the issue of presumptive hearings. In my view, it's an easy choice. Our clients' litigation budget can be stretched, and it's going to improve access to justice and free up lawyers' time to serve more clients, because we're not sitting around at the courthouse or in traffic. But over to you, Shannon.
Right. Yes, I echo what Russ said. Thank you so much to Professor Bala and Dr. Birnbaum for shedding light on this topic and conducting this survey and being here today to share the results, and to the Family Ad Hoc Steering Committee for sharing your positions on this as well. And of course, we want to extend our gratitude to everyone who was listening today. We appreciate you being here. So thank you again, everyone, and we hope to host you again soon.
Thank you, Shannon. Have a great afternoon, everyone. Thanks to our audience for tuning in.